During a medical malpractice lawsuit, if I catch the doctor in a lie during pretrial testimony, can I use that contradiction, that lie, at the time of trial? You want to know the answer? Come join me for a walk in downtown Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, most definitely, yes. I can use that information. I can use the doctor's sworn testimony in his pretrial deposition. Now, you should know that a pretrial deposition is a question and answer session that's given under oath. And when I say pretrial, it means that it happens a number of years before we ever get to trial. You see the squirrel hanging out behind me? How wild is that? Look at that. He's got a nut in his mouth. Okay, so this pretrial question and answer session takes place at least a year, if not more, before we ever get to trial. Now, how is it that I'm able to establish that the doctor lied about something? Well, when I say lie, I don't mean something minimal. I don't mean something like, oh, I happen to have forgotten something that I may have seen in the hospital chart when I reviewed the record in preparation for today's questioning. No, no, no. When the doctor responds to my question in these pretrial depositions that lawyers also call an examination before trial, the answers that he gives represents his sworn testimony. And now, that testimony can be read to the jury at the time of trial. So if I happen to catch the doctor in a lie, and not just some minor contradiction, not just something simple like, oh, I didn't remember it at the time, but I remembered it a year earlier, and I remembered it a year later, not something like that. I'm talking about something significant, where the doctor claims that he did or didn't do something, and in the hospital record it clearly shows that he did or just did the opposite. In that instance where that particular statement clearly contradicts what's contained in the hospital chart, then yes, I can use that contradiction that we would call a lie or an untruth to establish that this doctor is not credible. I can subpoena a doctor to come to court and testify. And now, if his testimony is different than what he testified to a year earlier during his deposition, now I can clearly show those contradictions to the jury. There are other ways I can use contradictions and untruths and lies when I go ahead and question a doctor at trial. It depends also on how the doctor testifies at trial. If the doctor's testimony is different than how he testified during his deposition, then that's obvious. I can read and explain and show to the jury the differences between his testimony now and the testimony before. I can confront the doctor about the discrepancies and the differences in his testimony now and what he did a year earlier. Or I cannot confront him or choose not to confront him. And then later on, after the doctor is off the witness stand, I can then pull out the transcript of his deposition testimony and actually go ahead and start reading those questions and answers that are contradictory to the jury. So the doctor does not have to be on the witness stand for me to go ahead and read those contradictory statements. Since doctor's testimony, his answers were sworn testimony and they were given under oath, I am permitted to use that information to show to the jury that this doctor gave inconsistent and contradictory information. And then at the end of the case, during closing arguments, I can ask the jury to draw various conclusions based upon these particular lies, based upon these untruths, based upon these things that simply don't make any sense, and ask the jury to draw specific conclusions about why the doctor lied and why the doctor should not be believed. But the bottom line is we can use contradictions and lies when they are at trial, and then it all depends upon how the witness testified to determine how we are going to use these contradictions in order to show that this particular witness is not credible. Now, in case you don't know, a witness's credibility is of the utmost paramount importance. If their credibility is shot, then at the end of the trial, the judge will give the jury an instruction that says, hey, if you find that a witness has testified falsely about one thing, you are permitted to disregard all of that witness's testimony, or you can disregard some of their testimony. That's up to you. But credibility is everything in any type of medical malpractice case, every type of wrongful death case, every type of personal injury case here in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.